It's you've had a somewhat of an unfortunate year in terms of weather, with a lot of canceled classes in the fall, and now 2 days of canceled class this semester. So my goal was to schedule this as quickly as possible so the information is still fresh in your mind. I don't know if it's actually going to work, but I'm glad as many of you here as can be. Hopefully you all stayed safe. No one hit any black ice or anything. I drove here at 59. There was no ice that I could see. So I never got a chance to go over the syllabus. I'm going to do that in the next class to make sure everyone's here to see that. But I will do that for you for today. The attendance is available. I'll leave it open throughout the entire class, so please check in using your app or on your laptop. The second thing, I know a lot of you do have class starting at 9. I'm going to pause around 8:50, take a break. You go to your other class. I apologize for scheduling classes over classes, but there's no good time to do this. The fact is there are not many empty rooms available for a class of this size, so you can get you all in one place. So this is why it's been 8 a.m. to guarantee there's actual rooms available. The other room has another class coming in. What else? If you do need to leave early, that's fine, but please watch the video of the remainder and email me, and I will certify your attendance, and everyone will be in good shape. Okay. If you did not get a name card, I don't have them here. They're locked up in the room. So at 10:40, you can get one then. All right. I think I got everything. Anything else in your minds? Any other questions before I get started? Any other questions before I get started? No? All right. So if you didn't check in, just see me after class. I'll mark you present. Okay? I like to start off our class with a clicker question. They're usually true-false. Sometimes they're multiple choice. But the questions always are designed to get you thinking about what we covered last class and what we're going to be covering this class. So I want to try a true-false question and see how you do. Okay? So the question's this. Everyone can see it. The decisions of the Supreme Court are the supreme law of the land. A is true, B is false. Don't put C. Without fail, one of you will put C and you're wrong. I know who you are too, so don't. So, look, I don't grade these. In other words, I'm not going to grade you right or wrong. But if I see you not participating, I might talk to you. So make sure you always take these seriously, but they're not graded. So I'll give you another 20 seconds or so. And if you came in late, I'll mark you present after class. Don't worry about it. I'll be a little bit more forgiving with the 8 a.m. start time. All right, another 10 seconds. You've got a minute to do these questions. All right. Let's see. All right. I'm going to stop it there. Actually, I'll let it run. I found that when I hit the stop button, it shows you the results, and I don't want you to see the results quite yet. All right, so, sir, over here. What's your name, sir? I'm sorry? John. John? John, what did you put here? Okay, why'd you put false? The Constitution is the supreme law of the land, right? Why do you figure that?
I think it's definitely the Constitution.
It is. Did you pay attention last week? That's good. You're right. You're right. Oh, I'll put. You give me a good answer. Okay, is that Gabriel? No. Oh no. Okay, what's your name, man?
Ava.
What's that?
Ava.
Ava, what'd you put here?
I put false.
You put false. Okay, why'd you put false?
Same thing. The decisions they made talk about the Constitution ultimately.
Okay. But, Ava, how are you supposed to know then what the supreme law of the land is
if the Supreme Court isn't the one telling us? Yeah, but these questions aren't always clear, are they? I mean, sometimes you have to think about it. It's not obvious on the face of the Constitution what the answer is.
I think they can try to figure out how it should be interpreted, but it's not always correct.
Wait a minute. Gabriel. Albert just said the Supreme Court might be wrong. How can the Supreme Court be wrong?
I mean, they can control state regulations and local. They affect federal laws.
Well, that's mostly correct. But if the Supreme Court makes decisions, why is that not the authoritative interpretation of the federal Constitution? Why is not the Supreme Court decision? That's it. Whatever they say, that's what the Supreme Court, that's what the Constitution means. Why is that wrong?
They interpret how the law should apply, but not necessarily the Supreme law of the Supreme.
Who gets to decide that then? Is that Colby?
Yes.
Colby, who gets to decide what the Supreme law of the land is? It's not the Supreme Court.
Well, the Constitution overrules that with the supremacy clause.
The supremacy clause. I think that's what John was getting at a minute ago. Let's bring it up. I have it up on the screen. Let me scroll. Okay. Okay, so here it is, right? If you have your little pocket constitutions, right? If anyone has a page number, it's Article 6, Clause 2. Please bring these to class every day. Don't lose them. I give these for what you get a freebie, so don't lose it. It's on page 55, right? I'm sorry, page 54, right? You want to read it first, Colby?
I actually left the little one at my...
It's right up here.
Okay.
Can you read that?
The Constitution and the laws of the United States which shall be made in pursuance thereof, and the treaties made of which shall be made under authority of the United States shall be the supreme law of the land. And the judges in every state shall be bound thereby, and anything in the Constitution or laws of any state to the contrary notwithstanding.
Okay, what does that mean in your own words?
That no matter what the state or any courtship says, if it violates the Constitution, it's not the law of the land.
Okay, good. And how do we know it violates the Constitution?
By the Supreme Court. They make the ultimate decision.
So is a decision of the Supreme Court itself the supreme law of the land?
No,
Why not?
because of Article 6 of the Constitution.
But I'm trying to push you on this, right? How do we know what the supreme law of the land is? The Constitution doesn't explain it. You're an entire class, right? Look at that big fat book I made you buy, right? If all you needed was a Constitution, I could get this little book, you'd be done with it. I made you buy this big fat 1800-page book, right? Right. What are we supposed to know then, right? About how do we know what the Constitution means? And is the Supreme Court decision just it? Is that definitive?
It's not because the legislation can go back and change the laws. The Constitution was the judiciary will make Constitution.
Right, but that's still presuming the Supreme Court to make the final determination. Is the Supreme Court the only branch that can interpret the Constitution?
You know, there's legislation and the branch can interpret it, that doesn't mean they can actually make a judgment.
Why not?
Because of separation of powers.
Where does it say that?
The Article 2.
Does it say only the courts can interpret the Constitution?
How do you use the word interpret?
Scott, let me ask you this question. Say you're the president, right? You're elected one day. Good for you, right? You're asked to sign a bill, right? Congress passes a bill that says, we're going to shut down all newspapers. Too much fake news, right? Big problem, right? Congress passes this bill. What do you do?
We'll take some analysis in the old cartoon 40, 50 years ago. So each of the three branches has its own power to review. So the president has
You're president, right?
power.
You're president. You sign this bill saying all newspapers are shut down nationwide.
Yeah.
You sign it.
Yeah.
Why?
Because I find that it violates freedom of speech.
I'm sorry, you signed, you actually signed the bill into law?
No,
Do something else.
I can
What's that word?
veto.
Thank you. Yeah, you veto it, right? Now, did a court tell you you have to veto this bill?
No,
Why are you vetoing it? It's perfectly valid, Congress passed it, what's wrong with it?
because you are interpreting the
Ah.
Constitution.
Right. Is that kidding? Well, you ask the same hypothetical, right? You're a member of Congress, you're a representative, you're a senator. And a bill comes up for a vote, says that all newspapers must be shut down. Do you vote for that bill?
No,
Why not?
because I believe that it violates the station.
Did any court tell you to do that?
No.
No. So, if you learn nothing else from me in this class, nothing else, the courts do not have a monopoly on the Constitution. If you learn nothing else from me, you forget everything I ever say. Remember that much, right? If you go to the very next paragraph in Article 6, right? It's on page 54. It says the senators and representatives and members of the state legislatures and all executive and judicial officers shall be bound by oath to support the Constitution. Right? Basically, every member of government in the state and federal system is bound by this nice little purple book, right? Or whatever color this is. They're bound by this book, this Constitution. So it's not only the courts that get to interpret the Constitution. In fact, most interpretations of the Constitution happen in the executive branch. They happen in Congress. Very few cases ever actually get to the federal courts because most bad ideas are shot down, right? If someone proposes a bill saying, let's shut down the newspapers, that's not going anywhere because individual members of Congress, like me or President Scott, right, would shut it down at the outset. So let's go back to this question then, right? We have the very outset. The decisions of the Supreme Court are the supreme law of the land? The answer is false, right? Right? Let's see how you guys did. Results. Good. Good. About a third of you. This is usually the breakdown, by the way. Usually about a third of you get it right. I'm sorry, a third of you get it wrong. That always happens. But the answer is false here, right? B. Right? You're going to read a decision later on where the Supreme Court itself says our decisions are the supreme law of the land. A case called Cooper v. Barron from the 1960s. It's wrong. I'll explain why. But this is correct, right? Simply because a court says something doesn't make it correct. Sometimes they're right, if they're not. People can disagree with court decisions all the time, but they do not have the monopoly. But now I want to ask a follow-up question of, Michelle. Let me ask you a follow-up question, please. It's a little bit tougher. Why do people follow courts? Why do people follow the decisions of any court?
If they decided on something, so you feel like we have to follow them?
What do you mean you have to? Says who?
I'm not sure who says it, but
Well, I asked you a question. Do people have to follow courts? You said yes, without any hesitation, right? That's when follow-up, now you're not so sure. Why do people have to follow courts?
they're the ones who are in charge of deciding what's
Says who? Where does it say that? Didn't we just say 5 minutes ago that every member of government has an oath to the Constitution? Legislative, executive, state, everyone. Says who? Michelle. Everyone takes an oath to the Constitution, not just the judges. Daniel, what do you think? Why do people follow court decisions?
What else we could go off of?
I elaborate. I think you're on the right track, but give me a little bit more, please.
When we're, they interpret the law, and I guess Congress, they have to kind of, I'm not sure.
What happens if, we'll use the first case as an example, Marbury versus Madison, right? What happens if Chief Justice Marshall held differently, right? What if Chief Justice Marshall held, give William Marbury his commission, make him a judge? And then Thomas Jefferson said, screw you. entirely plausible that could have happened, right?
So it's the legislature, or it's the judicial branch's power?
Yeah, but my question is, what if the president's ignored the court? Said, you know what? I don't want Marbury as a
What's
judge.
the point of the judicial branch?
Cameron. So then again, why do people follow courts if they can easily ignore it? It would have taken Jefferson 5 seconds to ignore the ruling and say, you know what, forget it.
You have to imagine, part of it is you kind of undermine yourself.
Ooh, tell me why.
Well, if you're, say you have something and it gets challenged, and if you've previously said, well, if they say this way and I didn't like it, so no, I'm not gonna follow it, then how would anyone follow it if they do something you want?
Ah, so what you're saying is you might need the courts in the future to depend on. So if you ignore them today, tomorrow they may not be there. Is that Andrew? Andrew, what happens more broadly if court says, Josh, go do this, right? And I say, forget it, not going to do it. What happens to me? In general, not just President Jefferson, I ignore a court. Court says, Josh, go do this, and I say, screw you, not going to do it. Never do this, by the way. not legal advice.
They can issue a warrant for your arrest.
Okay, so does the judge take his robe and beat me with his little gavel? What happens?
He issues, like a warrant for your arrest.
Okay, so who actually picks me up, puts me in handcuffs?
Police,
Do the police work for the courts?
state troopers, Texas.
Which branch of government? You have 3 branches, right? Do the police or state troopers fall into? What are the 3 branches?
Judicial, executive, and legislative.
Okay, good. Where do you think the state troopers and the police fall into? If you had to guess.
Judicial, executive.
What does it mean to execute the law? What does that mean, Andrew?
To be like the enforcer.
Yeah, the executive branch enforces the law. I think it's a good guess that the police enforce the law, right? Protecting and serving, right? So, Andrew, what happens if the sheriff or the governor or whoever it is in charge of the department says, you know what? I think Judge so-and-so is an idiot. Ignore him. Whoa. Then what? How is the judge going to arrest me if the police aren't listening to him either?
Yeah, I guess he has the power of the Constitution.
And what's he going to do with that power? Throw the Constitution at me? I mean, you give me a paper cut, maybe it's not going to do much. Ma'am, what's your name?
Raven.
Sorry, what?
Raven.
Raven. What happens? What happens if I ignore the court and the police aren't going to pick me up and arrest me? I mean, what does that make the court? What happens to the court at that point?
I guess nothing. If the court uses the police to enforce the laws, and the police aren't enforcing the laws, then
Yeah. So the courts are really depending on the executive branch to make things happen, right? They can't do it by themselves. So is that Malia?
yes.
Malia, so then I'll ask again, why do people follow courts? Or why does the executive branch back up whatever a judge says, even if maybe the executive branch doesn't agree with it? Like, let's say example, let's say a judge issues an order saying that this police department is breaking the law, and this police department must change their practices and stop, abusing people, whatever, right? And the sheriff says, you know what, screw you, we're going to keep doing what we're going to do, and come arrest us. Who are you going to arrest us? You have no force, you have no army. Why do people follow the decisions of courts? You never thought about this, did you? No, that's why you're in this class. Why?
I would say they follow it to make the world or the country like go smooth.
Oh, good. You're on the right track. Give me more, please.
I don't know.
No, you're on the exact right track. Just elaborate and make the world smoother.
Like, we don't want conflict in our country.
Oh, what do you mean conflict? Good.
We don't want the power, like, we have our 3 branches, and for them to go against each other would kind of not, like, why us as, like, citizens, we look up to those branches to, I don't know, put the law, like, to tell us what and what not, like, to do, like, what's wrong and what's not.
Okay, very good. So what's your name?
Right.
Gray? Gray, okay. Ray, let me ask you this question. Malia said a minute ago that you can avoid conflict, right? The courts can avoid conflict, right? How does following courts reduce conflict? How does following courts reduce conflict?
Well, I guess it's because it's the people that have given the judicial branch power to govern them in that regard. It's kind of allowing a higher power to oversee.
Well, are the courts a higher power necessarily? Does the Constitution give them some sort of higher perch to interpret the law?
Not necessarily a higher,
But,
but they have the checks and balances.
all right, is that Stephen? Stephen, let me ask you this question, sir. Let's use the example before, right? Judge comes out and says, this Houston Police Department, you're breaking the law, you're abusing people, right? Brutality. Sheriff says, you know what? No, we're not. We're doing just fine here. And we're going to keep doing what we're going to do, right? We're going to ignore your ruling. Come arrest us. Can't. No police. What's going to be the result where the judge says one thing, police department says the other, and some poor guy gets beat up by the cops? What happens then, right? What's the consequence there?
I mean, it's just kind of like I don't see mutiny, but like this, like to where you're not listening to the authority, like the people just won't follow or listen to the courts decisions in the future.
Right. So you see the conflict that emerges, right? Even though there's no constitutional requirement that courts have the final word, when courts don't have the final word, it makes things very messy. Everyone see what I'm talking about, right? It creates a lot of conflicts where there's a lot of doubt and uncertainty about what the law of the land actually is, right? So you have some guys say, hey, judge says you can't beat people up. And the police officer says, I don't listen to that judge. My sheriff interprets the Constitution also. And he says, I can do this. So courts are followed for a lot of reasons, one of which we like finality, right? As a society, we like things to be settled. We don't like conflict. We don't like disagreement about what the law is at any given point in time. I think also Cameron said this point a few minutes ago. We follow the courts today because we want to depend on them tomorrow. If we start ignoring the courts when it disadvantages us, they won't be there when it will be to our benefit at some point in the future. Right? And also, as a matter of practice, we have 200 years of experience where, for the most part, courts issue their decisions and everyone more or less goes along with it. That is not always going to happen. We will do some cases later on this semester from the Civil Rights era where, as part of what's called the massive resistance, efforts were made to dodge court judgments in every conceivable way to resist integration. So it's not a guarantee that courts are followed. In fact, it's one of the blessings of our republic that they are followed. If you look in other countries, very often the case, the court says something and they're ignored. So if you look at your name tags on your computer, it's hard to see because this class is very packed. I can't see their logo. Is that Ambrose? Ambrose. Okay, let me ask you another question, right? What does it do to a court if judge says, President, do X, and the president says, nah, I'm not going to do it? How does that make the court look? What does that do to the court's power?
Well, it would seem like it kind of reduces it. Doesn't really have no authority or weight behind it.
Oh my God.
Yeah. So if the president starts ignoring the courts, Ambrose, what are other people going to do? Same. Ever hear what he said? Another reason why people follow courts, because if you don't, they lose their legitimacy, right? They lose their power to tell people what the law is. that's a very significant consequence. Because if you don't have courts that have the ability to issue respectable judgments, then people can simply blow them off. So the answer I posed at the very beginning of class, right, are the decisions of the Constitution, are the Supreme Court's decisions the supreme law of the land? The answer is false. That's easy. But for practical purposes, when the Supreme Court speaks, that's pretty much the end of the road. Unless the Supreme Court reverses itself, which undermines the entire notion that they are supreme law of the land. The only way to change the Constitution is with an amendment, right? You know this. You can amend the Constitution, it's very hard. Or you get another justice to reverse it. So a 5-4 decision that goes one way, a new justice comes to the court, 5-4 decision goes the other way. Has the text of the Constitution changed? No, still the same, 200 years. What changed was the membership of the court. So the notion that justices can even make supreme law of the land is a fallacy, because they can reverse themselves with one vote. Well, we won't do this case, but there was a decision called Citizens United involving campaign finance, beyond the scope for a class. 5-4, very, very contentious decision. There was a movement to amend the Constitution to reverse Citizens United. It was never going to. It would never happen, right? What would happen? If one more justice was put in the court to replace Justice Scalia, Citizens United would have probably been reversed. So, to prove the point that the statement's false, as absolute proof, the fact that one member of the court can change the meaning of the Constitution means it can't be supreme law of the land. Okay. Any other questions at the outset about this? Okay. Anything? All right, let's do Marbury, and I'll let you. I'll start Marbury. I'll let the rest of the class go after that. So I think I said something in my last class. I mean, that may at least one of you have said, saying that John Marshall is very much overrated. I think he is. I think he's probably top 2 most overrated justices of all time. I go back and forth. Olive Wendell Holmes and Marshall, who's worse, but it depends on my mood of the day. The reason why is you all were taught wrong. You all learned that John Marshall, the great Chief Justice, right, invented judicial review. It's simply false. It's not true at all. English courts have been setting aside laws as contrary to the English Constitution for generations. The idea of courts setting aside laws is not new. If you read the notes of the convention, virtually everyone assumed that the judiciary would be able to set aside laws that violate the Constitution. And the thinking was actually fairly simple, right? Judges have a duty to follow the higher law. Judges always have a duty to follow the higher law. So if you have a statute and you have a constitution, which one's higher? Constitution. So the statute must give way to the Constitution. How do we know this? Go back to the Supremacy Clause. Right? Look at the order. The Constitution, and then the laws of the United States. The Constitution, and then the laws of the United States. First comes the Constitution, and then come statutes by Congress. Hierarchy, right? Constitution on top, statutes underneath. So a statute that is not consistent with the higher law of the Constitution has no effect, right? Because the Constitution is more supreme. If you read Hamilton in Federalist Number 78, which I had you read for last week, right? Hamilton describes this judicial duty and states that laws contrary to the Constitution will be set aside. So Marshall didn't invent judicial review. He's not even the first judge to use it, not by a long shot. I think, in fact, Marshall, as you'll see, basically plagiarized Hamilton. Marshall's opinion in Marbury basically plagiarizes Federal 78. Marshall's opinion, McCulloch v. Maryland, basically plagiarizes Hamilton's letter to George Washington. I hold Hamilton in much higher esteem than I do Marshall. Anyway, enough Marshall bashing. Let's go to the actual case. You'll have plenty of Holmes bashing later this semester. The facts that gave rise to Marbury are very significant. By the way, was everyone able to watch the video? Okay, so this is new. You're probably the first law students in the country to see this. My co-author, Randy Barnett, who teaches at Georgetown, and I are producing a series of videos. We only have about 8 to start, but our goal ultimately is to have one for every case in the book. And the thinking is, before you come to class, you will watch these videos in addition to your readings. It's in no sense a replacement for your readings, because it gives you a very small snippet, but it gives you the context of these cases. And eventually I'll have videos for the entire semester, probably not for your advantage, but eventually I'll have them. So please, if you have feedback on these, you can tell me now or after class. But I encourage you to watch the videos when you can. But the context in which this case arose is very significant. It all begins with the election of 1800. As the Constitution was originally designed, you didn't have the president and vice president run in the same ticket. What happened is everyone would run for president. And whoever got the most votes would be president, and whoever got the second most votes would be vice president. Now, as you can imagine, that didn't work out very well. Could you imagine having a President Trump and Vice President Clinton? That would be insane. But you had something very similar. In the election of 1800, you had Thomas Jefferson and Aaron Burr. These people hated each other. They tied in the Electoral College. They had the same number of votes, which was probably a mistake. Shouldn't have been, but they tied in the Electoral College. What happens under a constitution when there's a tie in the Electoral College? It goes to the House. And after 30-something ballots, the House awarded Jefferson, who was a Republican, the presidency. And that made Aaron Burr the vice president. The consequence, though, is that the Republican Party was coming to power. At the time, John Adams was president. He was of the Federalist Party. This is not the same as the Federalist Papers, but the name is the same. So on their way out the door, the Federalists said, uh-oh, we're in trouble, right? We are going to be out of power. We don't have the presidency. We don't have Congress. We have to do something. So what did the Federalist Congress do? They passed what was called the Midnight Judgeship Bill, right? It was the Judiciary Act of 1801. Yeah, and this was a couple weeks before Jefferson's inauguration. I think in February of 1801, so a few weeks before the inauguration. What did this Judiciary Act do? Well, first off, it reduced the number of justices in the Supreme Court from 6 to 5. They were trying to block Jefferson from appointing more people to the Supreme Court. And President Adams nominated his Secretary of State, John Marshall, as Chief Justice. So John Marshall was simultaneously serving as Secretary of State and Chief Justice. No problem there, no incompatibility problems. You can be a member of the executive and judicial branch, no problems there. You can't be a member of the executive and legislative branches. Okay? What else did the Midnight Judge Bill do? It created the Midnight Judges. It established dozens of new federal court positions, all of which would be staffed with Federalist-friendly judges. The only problem was they didn't have enough time to actually fill all these positions in the complete fashion. So how's the judge appointed? The president nominates him. The Senate gives its advice and consent. Okay? At that point, a few things need to happen. The president must sign the commission, put his name on it, and then the Secretary of State must put the seal of the United States on it. Now, what does this mean, put the seal? How do you know a signature is authentic, right? I don't know if it's not a forged signature. There's a wax seal that the U.S. government had. It would stamp
on the commission to authenticate it, right? You know this was a legitimate government document that had a seal on it. It was like, you know, you take a piece of wax, you put this thing on it. You know the Stevie Wonder song, Signed, Sealed, Delivered, right? It's basically this, right? You have to sign it, seal it, and then deliver the commission. It's like, you know, contracts. So at the very end, on the last night before the inauguration, President Adams signed a number of commissions, and he went to sleep. The story is Adams hated Jefferson so much that he left Washington, D.C. before the inauguration. He didn't want to be there. Right? He left like at 4 in the morning. He got out of town real quick. Then John Marshall, who was, again, simultaneously the Secretary of State and the Chief Justice, put the seal of the United States, this wax seal, on all these various commissions. Okay? So then they had one last thing to do. Deliver them. So Marshall, as well as Marshall's brother and a few others, were frantically, on the evening before the inauguration, running around D.C. and trying to deliver these, you know, these wax-sealed papers, these commissions, to the various judges. As often happens when you rush, you screw up. And they screwed up in a big way. Marshall failed to deliver the commission of one William Marbury. William Marbury was appointed as a Justice of the Peace in what's today Alexandria, Virginia, but what was then the District of Columbia. Okay? Marbury never got it in time. Just didn't get it in time. What happened next? Jefferson took the oath of office. Jefferson took the oath of office. In one of his first acts, Jefferson told James Madison, his Secretary of State, don't deliver any of those outstanding commissions. I don't want any of those federal judges on the bench. So Marbury never got his commission. But the Republicans did more than that. The Republicans abolished, they actually abolished these newly created positions. Now wait a minute, Josh, didn't we learn last week that federal judges hold their commissions for life and their salaries are guaranteed in good behavior? Yeah. Nonetheless, Republicans abolished all those Federalist judgeships. They repealed the Judiciary Act of 1801. They didn't stop there. They suspended the Supreme Court's entire term. They tell the Supreme Court, you're not going to meet for a year. In other words, we're putting you guys on notice that screw with us at your own peril. Okay? So then, poor William Marbury was like, wait a minute, I thought I was going to be a judge. Where's my damn commission? Right? He asked Madison, hey, can you make me a judge? He's like, no, you have luck. So that is what gave rise to William Marbury. But there's an important fact that you should not lose sight of. And please don't lose sight of this. Jefferson would not have complied with an order to give William Marbury his judgeship. He would have simply ignored it. We know this because the position was abolished, right? There was no position to fill. But even if the Supreme Court had come out and said, hey, he was properly confirmed by the Senate, give him his commission, Madison would have said, nope. Jefferson would have said, nope. So Marshall was acting in a very narrow space of action. In other words, there were very few things he could have done here. The bottom line basically had to be that Jefferson wins. But the famous jujitsu, as the video recounts, is how Chief Justice Marshall got the holding he did. Now, at the outset, all of you probably thought that Marbury was the greatest decision ever, right? I'll explain to you at the end of this case why I think it's wrong for at least 5 reasons. But not everyone agrees it's correct. In fact, I swear, 2 days ago at the Supreme Court, there was a case involving military courts. Specifics are not important for you. But one of the precedents at issue was Marbury versus Madison. Justice Kennedy, who indeed is our supreme overlord, he decides everything is important, posed a question to counsel
was actually a law professor at UT Austin, and he said, was Marbury versus Madison correctly decided? Even now, in the year 2018, 200-something years later, a Supreme Court justice asks, mostly in jest, was Marbury correctly decided? And the professor, who was a friend of mine, he basically said, well, I'm of the school of thought that thinks Marshall issued the decision he did to get to the conclusion he wanted to get to. So there's a lot to criticize this decision. Some professors don't even teach it. But for me, it's an important and valuable moment. Okay? All right, it's 8:45. I'm going to break here for about 5 minutes. If you have class afterwards, please excuse yourself. In other words, or if you don't, you can just stay here. But we'll take about a 5-minute break now, okay? Thank you. Be back at 8:50. Yeah, so 4 Zoom at 10:40. You have time, correct?
I mean, it's kind of hard because you have like 3 swipes per page kind of thing, you know? Yeah, do that, and this one and this other one. Terrible. That's why we needed the table of content.
Look, we're back. Someone set the clock at 2 minutes fast. I think since you did that on purpose to try and get class early, I'm convinced. It happens every year. But just, I'll fix it later. But anyway, 8:50. Okay. I hope everyone's settled back in. Again, if you were late coming in, just send me an email and I will fix your attendance. That's not a problem. I can take care of it later. Okay? Thank you so much. I appreciate it. Yeah, every semester someone messes with the clock in at least one of the rooms I teach you. It's without fail. So you got it 2 minutes early. Anyway, so 8:50 we're here. So you got an extra 2-minute break when I attended. You're welcome. I usually don't do a break, so this will be the anomaly. I actually did the math. If you take a 10-minute break, you basically lose 2 full class sessions over the semester. It's a lot. You don't have time to lose. All right, so let's talk about Marbury, right? We have the frame. There were 3 questions. 3 questions in Marbury to consider. First, did Marbury have the right to his commission? Second, if he had that right, does the law provide him with a remedy? And third, if the law provides him a remedy, can the Supreme Court give that remedy? So please separate those 3 questions. The first question is not developed much in your notes. It's almost taken as a given, so I'll summarize it for you. The law gave him a right. President Adams appointed him. The Senate confirmed him. Adams signed his commission and it was sealed. As far as the law is concerned, that was it. What about the fact that it was never delivered? Marshall says it's irrelevant. By the way, reason number 1 why this case is wrong, Marshall should have recused himself. He is the reason why Marbury didn't get his damn commission. This was perhaps the greatest breach of judicial ethics ever. Ever. No man should be a judge in his own case, except if your name is John Marshall. So the de-deifying begins. So the fact that it wasn't delivered was irrelevant. Okay? Second, does the laws of this country provide him with a remedy? Okay? Marbury brought suit under the Judiciary Act of 1789. This was one of the most important statutes ever enacted, ever. As we discussed last week, our Constitution only creates one court, the Supreme Court. And it said Congress may ordain and establish the lower courts, and Congress can set the lower courts' jurisdiction. One of the very first acts passed by Congress, the very first Congress in 1789, was the Judiciary Act of 1789. By the way, another reason why this case is probably wrong, when the very first Congress takes an action, it should be presumed that they acted lawfully. The people in the first Congress were in large measure the people who were at the Federal Convention. That is, the people who wrote the damn Constitution wrote this Judiciary Act of 1789. Yet Marshall goes and says, aha, they were an unconstitutional statute. Think about that for a second. Marshall says the very first Congress wrote an unconstitutional law. It defies reason. I'll explain why he's wrong. But it's a very bold holding. But Section 13 of the Judiciary Act of 1789 provides the Supreme Court can issue writs of mandamus. Writs of mandamus. Is that judge?
Yeah, Judge.
Oh, judge. What's your, okay? So what's a writ of mandamus?
Basically, it's saying that they have to do something. So in this case,
By the way, do you know the phrase apt to name? You familiar with the concept?
yeah.
Everyone also? So statistically, people with certain names are more likely to go into profession. So if your name's like Baker, you're more likely to be a baker. So I leave it to you, sir. So say again, what's a writ of mandamus? I cut you off.
Basically saying that they have to do something. So in this situation, the court is saying
Right.
that the president would have to
Exactly.
follow through.
Thank you. Yes, exactly right. Marbury said, hey, I want a writ of mandamus to be given to James Madison. That's why it's Marbury versus Madison, right? I want a writ of mandamus to be given to James Madison, and Madison can then direct the commission to me, right? So Marbury wanted a court to order Madison to issue him his writ through a writ of mandamus. One other aspect of this case that's not obvious, Marbury sued Madison. James Madison was one of the key architects of the Constitution. I think it's safe to say he understood a little bit about the document. What did Madison argue in court? Nothing. James Madison didn't even show up in court. That's how little Jefferson respected Marshall. They didn't even send a lawyer to the Supreme Court. Basically, Marbury was arguing against himself. No one was on the other side. So this case was wrong in so many ways. So many ways. Right? Can you imagine that? Marbury lost even though no one was arguing against him. That's like your worst nightmare, right? You show up in court, no one on the other side, you still lose. Right? So poor Marbury. Okay. So again, Marbury wanted a writ of mandamus. Okay. Is that Kelly? Mm-hmm. Kelly, is there any problem in theory with a court ordering the Secretary of State to deliver the commission? Is there any problem in theory with that? Putting aside whether the Supreme Court can do it, is there any problem with any court ordering the Secretary of State to give this judgeship to Marbury? What does Marshall say about this? Right? Why might this be problematic, right?
Well, Kelly, let me ask this question for you. Let's say Marbury brought his lawsuit in a different court, right? Let's say he brought it in a trial court that was allowed. And the court ordered Jefferson and Madison to give away this judgeship. Is there anything problematic about a court ordering the executive branch to take some sort of action? What do you mean? Kelly, let me ask you the question differently. Could a court tell the president, we want you to bomb this country, right? Or could a court tell a president, you should really negotiate a treaty with this other country? I think that's a good idea. Or could a court tell a president, you know, we really don't like this bill, you should veto it? Can a court issue that sort of order? Okay, why not, Kelly? Well, how would you describe that power that you mentioned? How would you describe that? What sort of decision is whether to bomb a country or to, negotiate a treaty or these sorts of things? Yeah, it's within the executive's discretion, right? Maybe not bombing a country, but at least negotiating a treaty, right? So there's certain types of political questions, right? Political questions are questions reserved to the political branches. And generally courts don't get involved in political questions. They just don't decide them, right? If it's an act within the president's discretion, a political question, the courts say, you know what, this is not for us to decide. But, now what's your name? Elena, thank you. Elena, is this a political question, though? The delivery of Marbury's commission? Is this in the president's discretion? Is this a political issue?
Yes.
What does Marshall say here?
It's not a political question.
Are you guessing? I'll come back to you. Bianca, what does Marshall say here? No, answer my question. You're giving me the next thing. Can a court in theory order the delivery of this commission? Is this a political question? Is this discretionary, the delivery? Why not?
Because if the court orders to execute, then they're overstepping their bounds.
No. Is this a political discretionary question? That's my question for you. Why not?
I don't know.
Is that Min? What's the answer to my question? So, in general, you need to pay really close attention to what your predecessors asked, okay? I'll repeat it for you. Is the court ordering the delivery of the commission a political question, discretionary in nature?
Well, John Marshall said it's unconstitutional for the court to issue.
But that's because it's the Supreme Court, right? You're giving me the answer to number 3. I'm asking about number 2. So I'm going to ask the question again. Is the delivery of the commission a discretionary act or not? Ruth? This is a really important part of the opinion.
I'm not sure.
So I have a colleague, I've never actually done this, but I have a colleague who has a policy that if 5 people in a row unprepared, she dismisses class, and this will be on the exam. I don't have the guts to actually do that, because I think a lot of people did read, so I wouldn't do that. But this is not acceptable. Kenny? Is this a political discretionary act, the delivery of the commission?
No, but I don't really know why.
Oh, you guys are killing me. Does anyone know the answer? Okay, I'll skip. What's your name, ma'am? Kendall, what's the answer to my question?
No, because it would be a right.
Why? How do we know that? Why is it a right? Ruben?
So the laws for
Yes. The law. Well,
You missed it at the end. It's not about the remedy. Why does he have the right? That's the question. Yeah, in the corner here. What's your name?
Dennis.
Dennis.
It says here the appointment conferred on him a legal right to the office for a space of 5 years because the Congress set it up.
Yes, thank you. Okay, that's the answer. By virtue of Congress, the Senate approving that position, he had a 5-year term. Once the commission was signed and sealed, it was no longer a discretionary act. It was what was called ministerial. It's like a clerical duty of delivery, right? I'm going to do this row over again in a few minutes. I'll come back to you guys, right? But the key question is this. Had a lower court had this case, they could have issued the writ of mandamus because it's not a political question. There was no discretion. Marbury had a right to his remedy, and Madison had a duty to deliver it. Right? Think about this. Madison had Madison had the duty to deliver the commission because it was a 5-year term in the statute. That is the length of the position. So long as that 5-year term was up, the Secretary of State had the obligation to honor it. He didn't do that, though. Right? He did not do that. So the first question, does he have the right? Yes, he has the right. The second question, right? Is mandamus available to make him get the commission? Yes. Mandamus is available. Okay? Mandamus is available because it's a discretionary act. That's question number 2, right? The remedy is available. But question 3, can this court, can the Supreme Court of the United States provide this remedy of mandamus, right? Even if he has a right and mandamus could give him the commission, can the Supreme Court give him this remedy? Everyone with me so far? If questions, stop me. So is that Elena? Let me come back to you, please. Where did Marbury file his lawsuit? Which court?
Is it federal court?
Which one? Really, it's the entire crux of the case. Bianca, which court did he file in? Yes. Did he file it in the lower court and then appeal to the Supreme Court, or did he file it right after the Supreme Court? Okay, very good. So this case was filed in the Supreme Court's original jurisdiction. Okay. This is an important concept. If you go to Article 3, Section 2 of the Constitution, okay, it's on page, I have the page is shouted out. Page 48, please. If you go to Article 3, Section 2 of the Constitution, this is the provision which defines the jurisdiction of the court. So, Elaine, let me ask you this question. When I say the jurisdiction of the court, what am I referring to?
Whether or not the court can hear the case?
Very good, right? A court can only act where there's jurisdiction. You learned this in Civ Pro, right? You have federal question jurisdiction, you have your diversity jurisdiction, right? If two people from Texas sue each other in federal court, it's dismissed. There's no diversity. If the amount is $75,000 and 0 cents, you don't have federal question. By the way, there was actually a case a couple years ago I was clerking where the amount in controversy was exactly $75,000 and 0 cents. Not enough. Penny short of federal jurisdiction. And the best part, no one realized this until it got to the Court of Appeals. No one. Can you imagine the lawyer's look on his face when the judge goes, "Counselor, what's the amount of controversy? $75,000. You're a penny short." It was judged at the par in the Sixth Circuit. A brilliant opinion, though. Basically, I think the first line was a penny short. That was like the first sentence or something. You know? Courts, federal courts only act where they have jurisdiction, right? State courts have what's called general jurisdiction. You learned this. For example, the New York trial court is called the New York Supreme Court. right? Why is a trial court called the Supreme Court? Because they have supreme or general jurisdiction for every case you can imagine. Federal courts are courts of limited or specific jurisdiction. They only have the jurisdiction given to them by Congress or the Constitution. Now we know the Supreme Court was established by the Constitution. And here, the Constitution discusses the jurisdiction of the Supreme Court. It says, the judicial power shall extend to all cases in law and equity arising under this Constitution. By the way, federal question jurisdiction arising under came from there. Civ Pro is basically ConLaw. You didn't realize it, but you will this semester. Then it says, in all cases affecting ambassadors, other public ministers, and consuls, and those in which a state shall be a party, the Supreme Court shall have original jurisdiction. So what does that mean? If there's a case involving an ambassador, right, a foreign diplomat, his case will be in the Supreme Court. If there's a case where a state, perhaps suing another state, that case can go right to the Supreme Court. They don't need to start at a trial court. They can go right to the U.S. Supreme Court. Why? It's a big deal when a state sues another state. And it's a big deal when an ambassador wants to go to court, right? It's a really big deal. Okay. Next paragraph, it says, in all other cases, the Supreme Court shall have appellate jurisdiction. Okay, so for cases involving ambassadors and the states, original jurisdiction. For everything else, appellate jurisdiction. All right. Min, let me ask you this question. Just reading this section, right, Article 3, Section 2, is there anything in there that says Congress lacks the power to add additional grounds for original jurisdiction? I'm sorry? Why do you say no? You have to talk louder. I didn't hear a word you said.
It stated that only the Supreme Court have the original jurisdiction on those cases.
Right. So my question to you is this. Can Congress add additional things to the Supreme Court's original jurisdiction? Is there anything in the text prohibiting it? Does it say the Supreme Court will only have original jurisdiction over these few items?
No, the Congress
Can Congress add to it?
yes.
How do you know that?
It said under such regulation as the Congress.
Oh. So rule number 3, why I think Marbury was wrong. There's absolutely nothing in the Constitution which says that these grounds are exclusive. There's nothing in the Constitution that says only those items are permissible for original jurisdiction. Now, I think there's a good argument that it might be the case, but it's not necessarily the case. Right? But Marshall's reading, how does Marshall read this? He says, original jurisdiction is only for these 3 or 4 items. Right? The holding of Marbury is that Congress cannot expand the Supreme Court's original jurisdiction. Right? That Congress cannot expand the Supreme Court's original jurisdiction. How does he get there? This one is actually not bad. He says, look, for appellate jurisdiction, Congress can make exceptions. But there's no similar language for its original jurisdiction. And from this, Marshall says, Congress cannot touch the Supreme Court's original jurisdiction. It can't add to it. In fact, this is actually the case I mentioned earlier about original jurisdiction, that whether Congress can add to it. All right. Yes, sir, Jonathan.
What is a public minister and a consul?
It's the same thing as an ambassador. These are various diplomatic positions. Thank you for your question. Okay, so the first part of this section is Congress can expand the Supreme Court's original jurisdiction. Okay. We know, is that Ruth? We know from before that Marshall filed a lawsuit seeking mandamus
in the Supreme Court's original jurisdiction. Could he do this? No. Did you read the case?
I did.
Okay. Could Marbury bring a suit in the Supreme Court's original jurisdiction? This is the entire holding of the case.
No, because it doesn't have jurisdiction.
Why not?
To be in the court.
Why not?
Because it doesn't have a court jurisdiction.
Well, let's look at the Judiciary Act of 1789 again, right? Okay, Ruth?
Yes.
The statute, section 13, said the Supreme Court can issue writs of mandamus. Okay? Does that apply when the Supreme Court's hearing an appeal? Or does that apply in the Supreme Court's original jurisdiction? Does the statute specify whether it applies in the original jurisdiction or in its appellate jurisdiction? Section 13, is there anything about appellate versus original?
No.
So how would you read this statute if you were on the court? Would you read section 13 as trying to add to the Supreme Court's original jurisdiction? Would you read it that way? Kenny?
Yes,
Yes, what?
it does seem like it's trying to expand the.
Does it say anything about original jurisdiction in the statute?
It says the authority of the United States, so it just.
Why is that?
You could read it as just saying like the highest authority.
Why can't section 13 simply mean that when the Supreme Court's hearing a case on appeal, they can issue a writ of mandamus for an appellate case? Why can't you read it that way?
Doesn't mention anything about appealing.
But it doesn't say anything about original either, does it? Sam?
Because if they're the ones issuing the writ of mandamus, that means that they're the first case that heard it.
Why? Why can't you issue mandamus on appeal?
I mean, because in appeal, you're just reviewing what the original court did.
But why couldn't the Supreme Court say, we think the lower court's wrong, we issue the writ of mandamus ourselves?
Well, they would order the lower court to issue the writ,
Why can't the Supreme Court do it itself?
because that would make it original jurisdiction.
But if the Supreme Court's hearing an appeal, they say, we think the lower court's wrong, we're going to take care of it ourselves and issue the writ right now. Why can't that be possible?
I mean, kind of ruins the whole point of who has original jurisdiction.
So everyone see what Sam's point. It's a very good point. Sam's saying the usual matter is that the Supreme Court thinks the lower court screwed up, they reverse it, send it back down to the lower court, let the lower court issue the writ of mandamus. Sam, couldn't we just read this as saying the Supreme Court in its appellate jurisdiction can issue writs by itself?
Yeah, I think we could. I mean, but like I said, if you take away a power that a lower court has, then it kind of makes
Now,
their function.
Sam, let me ask you another question. This is actually a much more meta question, right?
Yeah,
If a court's confronted with two different readings of a statute, both plausible, one results in striking down the law, and the other results in upholding the law, which reading should a court prefer?
probably the one upholding the law, because, you know, the legislator being the voice of the people, it probably means that we want a law like that in place.
Right, so the fourth reason why I think Marbury is wrong, so I'm going through the list, right? I never remember 5, I'll get to it later, I think. I usually remember along the way, but the fourth reason is there's nothing in this statute which says you're giving it in the court's original jurisdiction. I think Sam's right, you could read it that way, but a better way to save the statute and avoid striking at an act of the first Congress, 1789, James Madison upright it, is to say this only applies to appellate jurisdiction, right? So I think Marbury probably read the statute, not in a wrong way for reasons Sam identified, but he could have read it in a safe way to defend it. Is that Cindy? Cindy, let me ask you a follow-up question then. Let's assuming that I'm right. Who knows I'm wrong. let's say I'm right for a minute, right? And let's say mandamus is only available in the Supreme Court's appellate jurisdiction. Marbury sought mandamus in its original jurisdiction. What should have been the outcome in this case then? Perfect. The entire case. Oh, this is number 5. I knew it was coming. This entire opinion is irrelevant. It doesn't matter. If a court has no jurisdiction, there should be a one-sentence order. Cindy, say it again. You said exactly correct. This sentence I could summarize in one sentence for you, right? Ready for this? Okay. Dismiss for lack of jurisdiction. Marshall, recused. Done. You have to read this long, winding, complicated opinion, which was all a dicta. There was no actual holding here because there was no jurisdiction. When a court lacks jurisdiction, they can't do anything. Cindy, I think, said exactly right. One sentence. Dismiss for lack of jurisdiction. Mr. Marbury, I'm sorry. Go file in a lower court. Right? Go file this in a trial court. And then maybe we can take it up on appeal later. He never did, by the way. He never saw it again because the petition was abolished. But the entire case, yeah, this is number 5. I always forget number 5. The entire case could have been dismissed with one sentence. Dismissed for lack of jurisdiction. That's it. So Cindy's exactly right. The entire case is a waste of time. So then is that Witt?
Yeah.
Witt, tell me this. Why did Marbury write this long, convoluted, winding opinion if at the very end he says, sorry, I don't have jurisdiction, we've got to dismiss the case? Why on earth would he make millions of law students for the last 200 years read this thing, right? I mean, everyone reads this case. Why did he torture you, Witt? Why did he ruin your snow day? It's not a snow day. There was no snow. I'm sorry. I'm from New York. It's very silly to me. This winter blast with like a centimeter of frost, but whatever. Why did Marshall do all this stuff?
Because it involved an issue between the separation of powers when it was novel. It hadn't come up to the court, so he wanted to establish precedent.
Oh, give me more. You're on the right track. Thank you.
That was about it.
Oh, you said he wanted to establish precedent. Give me a little bit more on that, please.
I mean, no one had really decided this issue about what congressional authority was and what judicial authority was in practice versus what was said in the Constitution.
Okay, so again, Marshall didn't invent judicial review, but this opinion was used to establish it as a federal practice, right? This was one of the first instances where a federal court struck down an act of Congress. Again, Marshall found unconstitutional Section 13 of the Judiciary Act of 1789. This was a law drafted by James Madison and enacted by the first Congress, signed into law by George Washington. If you're going to tell me that all those people enacted a blatantly unconstitutional statute, I'll tell you you're wrong. This is why when Justice Kennedy asked a professor from UT Austin, was Marbury wrong, he basically said, well, some people think he wrote this opinion to get to a certain answer. I think he's right. This is not how judges should judge. He should have recused, and instead he wrote this convoluted opinion that was designed to reach a result which he wanted to get to. It's indefensible, utterly, which is why I am not a Marshall fan. I am not a Marshall fan at all, in the least. You'll see why when we do the next case. But the bottom line, though, is that he established that now the courts will use this power to set aside laws that are contrary to the Constitution. And because he didn't actually order James Madison to deliver the commission, there was nothing for Madison to ignore, right? Madison couldn't ignore this ruling because it didn't tell him to do anything. It didn't affect him. The case was dismissed for lack of jurisdiction, right? The very last sentence of the opinion, dismissed, right? The writ is dismissed. You go to the very end. The rule must be discharged. Thank you. Right. That's it. Case goes away. So there's nothing binding on the executive branch. There's nothing to do. So this was the jujitsu, if you remember the phrase that was used in the reading. Right. So the holding of Marbury, right? 3 parts. First, Marbury had a right to the commission.
Second, mandamus would be available to get him the commission. But third, the Supreme Court lacks the authority to issue the writ of mandamus into original jurisdiction because this Judiciary Act, Section 13, is unconstitutional. So the bottom line is, Marbury's still not a judge. And the Supreme Court issued this convoluted opinion, which has tortured generations of law students from time immemorial, and you are now the latest inductees. Questions on Marbury? Yes, sir, Sam.
Is there a reason he didn't talk about the Repeal Act? I mean, because
Yeah.
aren't the only ways you're supposed to lose federal judgeships through attrition and not good behavior?
Yeah. So everyone understands Sam's question. I mentioned earlier in class that under the Republican Congress, the judgeships, the midnight judgeships, were abolished. Okay? There was a second case decided, I think on the same day as Marbury. It might be off by the day, but it was basically decided the same time as Marbury, called Stewart versus Laird. Someone can check me on the date. Stewart versus Laird. And, it was 1 week after Marbury. That was it. Everyone thought that Stewart would be the big case and not Marbury. But in fact, Marbury was the big case. Stewart was only maybe a page or two long. And this was actually a suit brought by one of the judges who had his position abolished, seeking his salary. Saying, look, I was given a tenure of so-and-so years, whatever it was, and you're not paying me a salary. The Supreme Court's opinion in that case was almost inconsequential. They basically dismissed it, saying that the case is not properly brought. They basically, I don't want to bore with the details, but they didn't even touch the constitutional question. So in the same week that the court issued this convoluted thing about the 1789 Act, they basically ignored the Repeal Act. You just Google it, Stewart v. Laird. It's a very short opinion, maybe a page or two. And it said, well, this case is not properly before us, it's not this and that, and they ignored it. So no, they never actually confronted the question of how the judgeship could be abolished. And that is why Marbury never filed suit in a trial court, right? Marbury never got his do-over. He basically said this, screw it, I lost, right? But very good question. Yes, sir, Trey.
How does, if the Constitution calls for the Supreme Court, how does Congress not let the Supreme Court sit for a year?
Well, same. The statute that exists now says that the Supreme Court meets the first Monday in October, right? So Congress can prescribe when the court meets. I think in that case, that Congress will meet October 1st of the next year. Does that interfere with the judicial power? Probably. At the same time, there was an impeachment of Justice Chase, Samuel Chase, not Salmon Chase, but Samuel Chase. And the Republicans tried to impeach Justice Chase for issuing rulings that were against the Republican Party. He was acquitted in the Senate. But this is a very dangerous time to be a judge. Very dangerous time. The irony is that most of the appointments from Jefferson and Madison to the Supreme Court agreed with Marshall. So Marshall had such an outsized influence that even these Republican judges came along with this Federalist agenda. As we'll see in the next case of McCulloch, as well as Gibbons.
And Prigg. Okay, what else? Anything else on Marbury? Very important case, very important case. Overrated, but important. I think I gave you a little 5 reasons, yeah. Okay. All right. So any other questions on Marbury before we move on to McCulloch v. Maryland? No? Okay, let's do McCulloch. All right. One of the first major controversies in the Young Republic concerned whether the United States could charter a bank. Now, we think of a bank now as, Bank of America or Chase or Wells Fargo, right? It's a place where you can go and you can get currency, you can have deposits, etc. A federal bank, though, is something very different. You may not think about this, but paper money, right? Dollar bills. Those didn't really exist as legal tender at the time of the founding. We read about this in the second case.
money was coins, silver, gold, and one of the powers of Congress was to coin money and set the weights and measures, right? So it says this weight of gold is equal to $1, or whatever it happened to be. How was the young government supposed to maintain repositories of money? Make sure that there were branches of this bank in different states so their currency could be exchanged. Right? So one of the ideas by Alexander Hamilton, who was the Secretary of the Treasury, was to charter or establish a bank, a federal bank of the United States. And this occasioned a serious debate, a significant debate in the early republic between Hamilton on the one side and Jefferson on the other. So imagine this, right? You're President Washington, and your cabinet consists of Secretary of the Treasury Alexander Hamilton. And he's telling you, yes, you can create this bank. And then you have your Secretary of State, Thomas Jefferson, and his associate, James Madison, saying, no, 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 you can't charter this bank. Who do you listen to, right? These are some pretty influential, important people, right, who knew a thing or two about the Constitution. So I'm going to play you a clip from the Hamilton musical. And I think I mentioned this, but I have tickets for Hamilton's coming to Houston in March or April. The highest midterm gets a ticket. So there's your incentive. You'll be seeing with my highest midterms from last semester, so make some new friends. Also, I actually got a takedown request, this is hilarious, of my lecture from last year. Because I played the Hamilton song during my lecture last year, and I got a takedown request on YouTube saying I violated their IP. So I'm actually going to mute the audio while I play this clip, which I know sounds insane. So I'm going to mute the audio so that way they don't take down my lecture again. So I'm actually annoyed because I usually can't watch my lecture. It makes me very unhappy. I apologize. So what this scene is, I'll set it up. It's called Cabinet Battle Number 1. And it's a battle, a rap battle, if you will, between Jefferson as Secretary of State and Hamilton as Secretary of the Treasury. And they're arguing about whether the Bank of the United States is constitutional. You will learn more about this case from 3 minutes of the Hamilton song than I can give you in an hour. So let me play this. Turn off the audio. Sorry, lecture. All right. If you couldn't hear it, I apologize, but I'll summarize. There was a huge sectional conflict. The northern states, which were involved more in trade, wanted this bank to have credit with foreign nations. The southern states, which were agrarian, didn't want this. They mostly wanted to export. So import versus export, big differences. Hamilton eventually persuaded Washington to sign it. But the debate wasn't merely about policy, but whether to have the bank. The debate was also about the Constitution. Jefferson and Madison argued that Congress didn't have the power to charter a bank, to establish a bank. Hamilton said they did. If you read John Marshall's opinion, basically plagiarized Hamilton again. Not much originality there. So let's walk through the constitutional arguments. Okay. I described for you last week that Congress's powers are enumerated. Okay? What does that mean? Congress only has those powers that are listed in the Constitution. And almost all of Congress's powers are listed in Article 1, Section 8. Don't forget that one, Article 1, Section 8. And I'll give you an example last week, which I'll use again. Who am I up to? David, thank you, sir. David, so Congress has the power in Article 1, Section 8 to establish postal roads, for example, right? Does Congress have the power to hire letter carriers and buy horses and buy wagons? Is that written anywhere in the Constitution? No. So can Congress have a postal service without horses and wagons and letter carriers and the like? No. So what gives Congress the power to pay for horses and wagons and letter carriers? Very good. So we have to understand about Article 1, Section 8 is the final provision, is often called the sweeping clause. Okay? It gives Congress additional powers. Let's read it. This is called the necessary and proper clause. Very important. The Congress shall have power to make all laws which shall be necessary and proper for carrying into execution the foregoing powers. So David, what are the foregoing powers? What does that refer to?
Enumerated powers?
Yes. This is Article 1, Section 8, Clause 17. If you turn to page 37. Oh, good, thank you. Page 37, so look at the bottom, right? This is the 18th clause in the provision. This is number 18. You can number them in the Constitution if you want. You don't have to. But this is number 18. What this is saying is numbers 1 through 17, okay? We're going to add on to that. In order to execute number 1 through 17, you can make other laws that are necessary and proper for carrying their execution to effect. In other words, if you want to have a postal road, you can hire letter carriers and buy horses if it's necessary and proper to have a postal system. Again, the necessary and proper clause is an additional grant of power. People often miss it, think, oh, it combined. It's a separate grant of power. So if you want to buy horses and wagons, you can do it under your necessary and proper clause. But this raises an important question, right? What does necessary mean? And what does proper mean? Okay? So what's your name? That purple shirt?
Robert.
Robert. So how does Marshall understand the word necessary? How does Marshall understand the word necessary here?
If it goes with the heart of the Constitution.
You're thinking of something else, but how does he understand the word necessary? That's my first question. Well, Robert, let me ask you this question. If I say necessary to you in regular context, right? Forget your law student for a minute. How would you define that? Right?
You have to do it.
Have to. Is it you absolutely have to, or is it helpful? Okay, so I think most people would probably agree with Robert, right? The word necessary means you gotta do it, right? If I say this is a necessary class for you to attend, that means you can't skip it. Right? So, Robert, let me ask you a follow-up. If I want to have a postal service at this time, is it necessary to have horses? Could you deliver horses? Could you deliver mail by foot for the entire country?
I mean, theoretically.
Yeah, see? So if you take necessary to mean strictly necessary, you can't do much. I mean, yeah, in theory, you could walk on foot and deliver mail. Doesn't say anything about horses or wagons. So Marshall and really Hamilton read the word necessary in a different fashion. Okay? He reads the word necessary to mean appropriate. Okay? Hamilton, and again, Marshall ripped off Hamilton, so I can start with Hamilton. Hamilton read the word necessary to be appropriate. Right? You might say convenient, helpful, maybe. Right? Is it convenient to have horses to run a mail service? Oh, absolutely. Is it absolutely necessary? Probably not. Is it necessary? Maybe. But Hamilton and Marshall read the word necessary to be very flexible. Very flexible. Okay? So that's how they read the clause in the abstract. Let's look at the bank in general. So what's your name?
Damon?
Damon.
Damon.
Damon, thank you, sir. Does the Constitution have a clause? Oh, were you on pass today? Okay, I think you emailed me that. So that's sorry, Kevin. Does the Constitution have a clause that allows the establishment of a bank?
No.
No. So there's no chartering of bank laws. But what provision of the Constitution is most relevant to chartering a bank?
The necessary and proper clause.
Which other provision? You're right, but what other provision?
I guess the clause for the enumerated powers.
Which one?
The third.
Okay, good guess. The Commerce Clause, right? So the Commerce Clause says that Congress has the power to regulate commerce among the several states. So I'll let you follow up, Kevin. I think I gave my answer away. I often do that. Does the power to regulate commerce mean you can charter a bank? Is regulating commerce mean you have a bank?
Not necessarily.
Not necessarily. Not a good word. Not necessarily, right? So Congress has the power to regulate commerce. Does that absolutely require you to have a bank? No. But is it helpful to have a bank to regulate commerce? Absolutely. Congress also has the power to coin money. Do you need a federal bank to coin money? No, you don't. But is it helpful to have a bank to coin money? Absolutely. What Marshall says is, there's nothing in the Constitution that expressly says you can have a bank, but in order to execute the foregoing powers, clause number 3, for example, coining money, for example, it's helpful, it's convenient to have this centralized bank. And here's the money quote, which you should have in your notes highlighted. He says, let the end be legitimate. Let it be within the scope of the Constitution. And all means which are appropriate, which are plainly adapted to that end, which are not prohibited, but consistent with the letter and spirit of the Constitution, our Constitution. Right, that's your holding right there. So long as the end's legitimate and the means are appropriate, that is, it's necessary, it's not for the courts to intervene. Marshall reads the Constitution in this fashion to avoid handcuffing the federal government. Because if you read the word necessary, as did Jefferson, I mean strictly necessary, there's very little the federal government can do. Right? They might not be able to buy horses. So Marshall's reading here was giving the federal government flexibility and the power to make a new nation. And indeed, that's probably why he wrote the opinion he did. Right? He is willing to read the necessary and proper clause, provide an additional ground of authority beyond what's strictly necessary. So that Congress has sweeping powers that if they can coin money, if they can regulate commerce, Congress can choose the means by which they do that effectively. And that can include the chartering of a bank. Right? Marshall wrote, "This is the Constitution we are expounding, that must endure for ages to come." What does that mean? We shouldn't read the Constitution so strictly, and we should read it to allow the government to function as they wish, to be a reflexive, to be an adaptive government. Okay? So whether or not Hamilton or Jefferson was right as an original meaning is a tough question. But Marshall's reading of the necessary and proper clause, again, has prevailed. Okay? So question, yes sir, Jonathan.
How else could they have borrowed money on the credit line in the United States without a bank? I mean, wasn't that the whole argument between them in that song?
So the Constitution allows the federal government to assume the debts of the states. So they probably could have done that as well, but the bank allowed them to give out loans and various other things to establish credit. So there are some things they could have done without the bank, but some things they need the bank to do. Okay. Other questions on McCulloch in Maryland? Right, the facts on McCulloch are actually crazy. I'll mention these briefly. The federal government established a bank in Maryland, in Baltimore. The state of Maryland said, "Oh, this is nice. We didn't approve of this bank. So we're going to put a tax on unapproved banks." So you basically had the state taxing this federal institution. And the federal institution refused to pay the tax. Think about for a moment what it's like if a state institution can destroy a federal institution. This, I think, will be relevant for the ongoing lawsuits against the president in state court. We'll maybe come back to it later this semester. But the facts of the case are pretty crazy. Okay, any other questions on McCulloch v. Maryland, right? Read the necessary and proper very broadly to mean convenient, adapted, etc. Any other questions on McCulloch v. Maryland? Yes, sir, Cameron.
So most of this goes about how he defines the word necessary. What about the word?
Oh, also, I was hoping you would ask it. Very good. Let me get the quote.
It's like you could need horses, but you need them, so you could just steal them, but that might be proper.
So, Cameron's exactly right. Marshall doesn't really put much attention to the word proper. He puts all his attention to the word necessary. He does mention it briefly. And what he says is that Congress only has incidental powers. That is, if it can regulate commerce, it has the power to do something small like charter a bank, right? But it does not have what's called a great and substantive independent power. What does that mean? Later this semester, we'll study the Affordable Care Act, Obamacare. In this law, Congress decided we want to regulate healthcare markets. We want to ensure that sick people can't be turned away from the health insurance, right? And in order to ensure that sick people can be guaranteed access to insurance, we're going to mandate that everyone buys insurance. And the government defended this as a necessary and proper power. The opinion of the court by Chief Justice Chief Justice Roberts, I get to confuse a lot, it's not a compliment. The opinion by Chief Justice Roberts held that it might be necessary for Congress to require people to buy insurance as a way of regulating the marketplace, but it's not proper because it intrudes on individual freedom. So you wouldn't get any court explaining proper until the 1990s, much later. But you will get to that later. Proper does come back into play. All right. Any other questions on McCulloch? All right. In my remaining 10 minutes, let's do Gibbons. The facts of Gibbons concern steamboats. Yeah, steamboats. Okay. Oh, I have a Barron as well. That's easy. New York established a monopoly. They said only one company can have their steamboats going to and from New York Harbor. Some other guy said, oh, that's nice, I want to compete with you. And it was a lawsuit. And New York said, aha, you are violating New York law. Now we know under the Supremacy Clause, federal law is the supreme law of the land. Right? Federal law is the supreme law of the land. If a state law conflicts with an act of Congress, the state law is unconstitutional. Right? If a state law conflicts with an act of Congress, it's unconstitutional. So here you had a federal statute regulating interstate shipment. And you have a state statute doing the same. If the federal statute was valid, what happens to the state statute? Unconstitutional. So the question was, could Congress regulate boat traffic between New York and New Jersey? In other words, Congress has the power to regulate, let me get you the phrase, clause 3, right? Congress has the power to regulate commerce among the several states. Okay? Is the regulation of boat traffic from New York to New Jersey commerce among the several states? Okay? The court holds yes, that it is. And they provide one of the first opinions about what commerce means. And Chief Justice, Roberts, I really get confused all the time. Chief Justice Marshall says that commerce means intercourse, exchange, right? It doesn't just mean buying and selling stuff, right? It doesn't just mean commercial transactions. He refers to it as intercourse, going back and forth between two states. Okay? So this provides a very broad reading of commerce. It gets much broader later. But this is one of the first instances where this Commerce Clause starts expanding. And I want you to keep this in mind. As the scope of the Commerce Clause expands, the power of the states to regulate shrinks. Because wherever Congress regulates, the states cannot. You know, they can't both be in the same place at the same time. When Congress regulates something, it displaces, it removes the states from that area. So if Congress regulates interstate boat travel, that means the states cannot do it because monopoly is unconstitutional. The second part of Marshall's holding concerns the phrase among the several states. Right? What does it mean among the several states? Now this case is actually fairly easy. You literally have a boat going from New York to New Jersey, right? I don't think anyone would argue that's among the states, going from New York to New Jersey, right? But Marshall's opinion is not so limited. He, again, reaches an issue not before him, but he discusses what happens if you have commerce that isn't necessarily so clear-cut, right? What if you have a transaction that is partially in one state and might go to another state? What if you have a transaction that is, exclusively in one state? Okay? He basically opens up the door to say, commerce doesn't need to be as clearly between New York and New Jersey, right? You could have a business transaction in one state that might affect another state. And he's opening up the possibility that Congress can regulate local activities that don't literally involve going from state A to state B. We'll study in class, in about 40 minutes or so, and thereafter, what it means to regulate commerce within one state. But Marshall's opinion here is fairly broad and opens up the possibility that Congress can regulate local conduct if it has some sort of effect on interstate commerce. He doesn't quite go that far, but he opens up the door for it. So Gibbons is a very important decision for you to learn, because first off, he defines commerce in a very broad fashion, right? Not just buying and selling stuff, but intercourse. And he defines among in a fairly broad fashion as well, to allow not strictly going from state A to state B. This is keeping with his opinion McCulloch. Why? It gives the federal government a lot of power to regulate many aspects of life that aren't solely within going from A to B. Right? He's opening the door to do a lot more stuff. What's going to confuse you, and we'll talk about this in about 40 minutes, is the court goes back and forth. Right? Marshall reads commerce very broadly. Marshall reads among very broadly. Chief Justice Chase, you'll read next case in DeWitt, reads it very narrowly. Then you get to the progressive era, they read it broadly again. And then other times they read it more narrowly. And the court goes back and forth. So what you have to do, and this is going to drive you nuts, is keep track of what year you're in. For the final exam, and I'll tell you this easily, one of the questions will be set today in 2018, and the other question will be you're set at some time in the past. You're in 1824, 1868, 1905, and you need to know at various times how is the Supreme Court considering commerce? Is it broad or narrow? You have to trace that arc. You can't know at any given point in time what the answer is. You're not going to like it, but you'll learn it so much better that way. The Supreme Court is not just an end game, right? Thank you, Taylor, right? There's stuff along the middle as, oh, come on, no one? There's stuff along the, too early, there's stuff along the middle as the court has evolved. You need to know that progression. So any other questions, or any questions on Gibbons? Sorry I did a little bit quickly, but this is a jam-packed class. And I'm sure I'll review it in 40 minutes anyway. And so any other questions on Gibbons? Last case. Easy case, but important case. Barron v. City of Baltimore. Now, I will not mention the First Amendment again for the last day of class. So you won't hear it again. But the First Amendment provides, Congress shall make no law respecting established religion, blah, 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 blah. Congress shall make no law. Who do the first 8 amendments apply to? Well, at least the First Amendment says Congress. As originally understood, the First Amendment didn't control the states. If a state wanted to establish religion, they could. In fact, a lot of states had official churches at the time of the founding. It's true. If a state wanted to censor the press, they could. If a state wanted to violate free speech, they could do that. Now, there might be a state constitution with limits, but the federal constitution simply did not apply. So the First Amendment is an easy one. Right? What about the Fifth Amendment? The Fifth Amendment provides, nor shall private property be taken for public use without just compensation. In Barron v. Baltimore, poor Mr. Barron complained, the city screwed up my harbor, I can't have my boats, they're taking my property, right? They didn't pay me for it. Did the Fifth Amendment apply to Maryland? Did the Takings Clause put restraints on Maryland's power? Chief Justice Marshall for the court holds that no, it does not apply. He writes that the Constitution was designed for the federal government alone and not for the states. And if the states wanted to put a restraint on taking property, the states could enact that restraint. There was no reason to extend the federal Constitution to the states. That was up for the states to decide what to do. This holding reflected the sentiment that the states had their own police power. Okay, what's a police power? The police power is the ability of the states to regulate the health, safety, welfare of the people. Right? It was for the states to protect the people and not the federal government. This would remain the rule until the 14th Amendment. The first 100 years of the Republic, until about 1868, the Constitution barely applied to the states. This would change with the Reconstruction Amendments, which eradicated slavery and guaranteed equal protection. And thinking was the states can no longer be trusted to protect the rights of their citizens. And over the following 100 years, the Supreme Court began saying all the provisions of the Bill of Rights apply to the states. The states can't violate free speech, they can't take property, etc. But in the 1800s, when Marshall sat in the court, the Bill of Rights, the first 8 amendments, did not apply to the states, and that's the rule you need to know. So if I give you a question, because I think it was my final exam last year, a lot of people got it wrong, involving the takings clause, did it apply to the federal government? Yeah. Did it apply to the states? No, it did not. Okay. Rock go through that one, I think I'm on pace. Questions on Barron v. Baltimore? And this is why I don't take a break usually. There's never enough time. So I'm already like 10 minutes short, but I'll indulge. Okay, questions on Barron? No? All right, I will see you around 10:40 in our usual room upstairs. And hopefully you enjoy your break and get some breakfast. Thank you so much.